All right. All right, gentlemen. A few important things. I'm Judge Dawson. Before we begin, I want to make sure you understand what.
This opening is crucial. The judge is laying out the defendant's constitutional rights, and this isn't just routine housekeeping. Everything said or not said from this point forward can shape the entire case. Pro tip: when a judge emphasizes your right to remain silent this early, it's a flashing red light that stakes are already high. Would you speak or say absolutely nothing?
Some of your primary rights are, first of all, you have a right to an attorney, and I believe you've had a chance to speak with the defense attorney here, or you may have your own attorney. If you have not had that opportunity, we'll make sure you get that opportunity. You also have a right to remain silent, which would be expressed through your attorney, which means you do not have to say anything when I call your name. You may be asked to come to the microphone with your hands visible, if that's able, or if you're capable of having your hands visible, then that's what we would ask you to do. Otherwise, you do have that right to remain silent. And then you have a right to what's called a probable cause or a preliminary hearing. That's a hearing for the purpose of the city to give evidence to the court that a felony was committed in this city and that you are connected to it to the point where I have to send it to the felony court to be resolved, meaning the felony cannot be handled in a misdemeanor court such as this one. When you speak with your attorney, the attorney will let you know that you can either have that hearing, you can request that hearing formally, or you can waive that hearing. If you waive the hearing, you're not admitting any guilt. Basically, you are allowing the case to be sent to the county for further proceeding. If that takes place, I will also set a court date for you so that you know when to appear at the county for your further proceedings. Also, I will set a bond for you here. We will hear from your attorney as well as the city's representatives in regard to the bond. And if you are electing to have a preliminary hearing, it has to take place within 10 days if you are still in the jail. But if you are able to make your bond that is going to be recommended and set, we have 15 days to have that particular hearing. But we'll let you know all that when we call the cases based on what the request is from your attorneys. First case is 18 CRA 01163, the City of East Cleveland versus Ronald Newberry. Good morning, counsel.
Good morning, Your Honor. For the record, K. Ranke, 216-374-7660.
Thank you very much. I have here two counts. The first one is a violation of 2903.01, a charge of aggravated murder. And then there's a second 2903.01 charge of aggravated murder. Those are felonies of the first degree, where you're looking at least 3 to 11 years in prison, up to a $15,000 fine, depending upon the specifications added to the charge. It could be life in prison or death. And it looks like in this particular situation, they have indicated that life is a possibility as well as death. The complaint states specifically that on...
Pause right here. This is the gut punch. 2 counts of aggravated murder, first-degree felonies with life in prison or even the death penalty on the table. This is no longer about what happened, it's about survival. Prior calculation and design means prosecutors are signaling intent, not impulse. That single phrase changes everything.
About the 10th day of October 2018 in the City of East Cleveland, Ronald Newberry did knowingly, purposely, and with prior calculation and design cause the death of Paris Bradley while committing or attempting to commit aggravated robbery and aggravated burglary. The second charge states that on or about the 10th day of October 2018 in the City of East Cleveland, Ronald Newberry did knowingly, purposely, and with prior calculation and design cause the death of Paul Bradley while committing or attempting to commit aggravated robbery and aggravated burglary. Counsel, in regard to the probable cause hearing.
Judge, I have gone over with my client. We would demand a preliminary examination.
Okay.
He has indicated so on the form and the advisement of rights form, which I can provide to the court. But we voluntarily surrendered a company, notified that there was an active warrant. I did call the detectives, made arrangements, and turned them in voluntarily to the East Cleveland Police Department last Thursday. We were informed originally that the court date was going to be on Tuesday. It was subsequently pushed back until today. I have accompanied Mr. Newberry to the detectives to speak to them on 2 occasions, as well as provided additional information in an effort to cooperate. It is my understanding that on at least 3 occasions, while he's been in the city jail outside of my presence, the detectives have brought him up, spoke to him in his jail, attempted to speak with him, which is certainly a violation of his attorney-client privileges. In addition, Judge, we made arrangements for his mother, who is not a suspect in this case, as well as his girlfriend, to speak to the detectives. His mother was arrested. Mr. Newberry was told by the detectives that his mother was going to remain in jail until such time that he confessed. His mother has been subsequently released. We are demanding a preliminary hearing, but I would ask for the record that there be no contact with my client outside of my presence by any law enforcement. We've also spoken to the prosecutors who were present last Friday. They are also aware of my representation.
All right. Thank you, counsel. So first of all, what we're going to do is set the preliminary hearing for Monday, November 19th, and I believe we set that time for 12.
Noon.
Yes.
Thank you,
So
Judge.
let's do that. And Counselor, appreciate your cooperation and the involvement that you've been, the steps you've taken to make sure that your client has been presented to the East Cleveland Police Department. So I appreciate that.
And here comes the reality check, a $5.3 million bond. Translation, this is functionally no bond at all. Courts do this when they believe the defendant is a flight risk or a danger to the community. The number itself sends a message. The system is not letting this person walk. Do you think bonds should ever be this high, or is this justice doing its job?
And I don't think it's unreasonable to make that request on the record and even in the presence of the court, that there be no contact with your client. So I do understand that. I'm sure the city understands that at this point. So we should not have any more problems in that regard. Detective or Madam Prosecutor, to the issue of bond.
Hi, Your Honor.
Sorry.
Good afternoon. For the record, Detective Joseph Marche, City of East Cleveland, assigned to major crimes in the Detective Bureau. For you, Ronald Newberry, black male, 23 years of age. We're not going to put his address out today. We're also not going to put any evidence out there today due to the fact that there is media here. Detective's bond recommendation is $5,321,770 cash surety, and that number is significant to the victim, Paul Bradley.
Counsel.
Judge, for the record, based upon the charges, I would leave the issue of bond to the discretion of the court.
Okay. All right. And I think what's important here is a couple of things. One is that obviously there's no more contact. We want to make sure that's done correctly and properly. We're going to set the prelim for Monday. And because of that, I think the bond recommendation, I don't see an adjustment that I would make that would make a big difference as far as Mr. Newberry being released today. So I will keep the bond set at the $5,321,770 and set the preliminary hearing for Monday at 12 noon.
Thank you, Judge. I just will ask to raise the issue of bond again after the preliminary hearing on Monday.
Absolutely.
Thank you, Judge.
Thank you very much.
Thank you, Your Honor.
And so the other